Hey, today we're looking at 20 questions on valid contracts. And before we get started, if you like this type of content, give us a thumbs up. Also subscribe so you don't miss any of our videos. We're here to help you pass your real estate exam. Also check out our channel. We have lots and lots of questions to help you pass your real estate exam. So here we go. What is a valid contract in real estate? A contract signed by both parties. B, a contract that meets all legal requirements. C, a contract that has been notarized. D, a verbal agreement between parties. B, a contract that meets all legal requirements. A valid contract in real estate must meet certain legal requirements, including offer and acceptance, consideration, legality of purpose, capacity of parties, and proper form. Which of the following is not an essential element of a valid contract? A, offer and acceptance. B, consideration. C, notarization. D, legal capacity of parties. C, notarization. Notarization is not typically required for a contract to be valid. The essential elements of a valid contract include offer and acceptance, consideration, legal capacity of parties, and legality of purpose. What is consideration in a contract? A, a promise to do something in exchange for something of value. B, the legality of the contract. C, the acceptance of an offer. D, the capacity of the parties to enter into a contract. A promise to do something in exchange for something of value. Consideration refers to something of value exchanged between parties to a contract, such as money, goods, services, or promises. Which of the following is an example of a valid consideration in a real estate contract? A promise to pay $1. B, a promise to give away a personal item. C, a promise to donate to charity. D, a promise to purchase a property in exchange for payment. D, a promise to purchase a property in exchange for payment. Valid consideration in a real estate contract typically involves an exchange of something of value, such as money, in exchange for property. What is the legal capacity of parties in a contract? A, the ability of parties to understand the terms of the contract. B, the ability of parties to enter into a contract. C, the legality of the contract. D, the acceptance of an offer. B, the ability of parties to enter into a contract. Legal capacity refers to the mental competence and legal eligibility of parties to enter into a contract. Minors, mentally incapacitated individuals, and those under the influence of drugs or alcohol may lack legal capacity. Which of the following is not a requirement for offer and acceptance in a valid contract? A, the offer must be communicated to the offeree. B, the acceptance must be unconditional. C, the acceptance must be communicated to the offerer. D, the offer must be made in writing. The offer must be made in writing. While some contracts may be required to be in writing to satisfy the statute of frauds, offer and acceptance can be made verbally or in writing depending on the circumstances. What is the statute of frauds? A law that requires certain contracts to be in writing to be enforceable. B, a law that prohibits fraud in real estate transactions. C, a law that governs the capacity of parties to enter into contracts. D, a law that regulates the formation of contracts. A law that requires certain contracts to be in writing to be enforceable. The statute of frauds is a legal doctrine that requires certain types of contracts, such as contracts for the sale of real estate, to be in writing to be enforceable in court. Before we go on for the rest of the questions, please hit the like button if you like this content. Go ahead, subscribe, hit the notification button so you don't miss one of our videos, and also check out our channel. We have lots of questions that will help you pass your real estate exam. Next question. Which of the following contracts is typically required to be in writing to satisfy the statute of frauds? A, lease agreements for less than 1 year. B, contracts for the sale of real estate. C, employment contracts. D, oral agreements between friends. Contracts for the sale of real estate. Contracts for the sale of real estate are generally required to be in writing to satisfy the statute of frauds. Keep in mind the words generally. Depends on your state. What is an executory contract? A contract that has been fully performed by both parties. B, a contract that is legally enforceable. C, a contract that is still being performed by one or both parties. D, a contract that has been rescinded. C, a contract that is still being performed by one or both parties. An executory contract is a contract that has not yet been fully performed by one or both parties. Which of the following would render a contract void? A, lack of consideration. B, mistake of fact. C, unilateral mistake. D, failure to notarize the contract. B, mistake of fact. A mistake of fact, such as an error regarding the subject matter or terms of the contract, can render a contract void if it goes to the essence of the agreement. What is the difference between a unilateral contract and a bilateral contract? A unilateral contract involves promises exchanged by both parties, while a bilateral contract involves a promise by one party in exchange for an act by the other party. B, a unilateral contract involves consideration, while a bilateral contract does not. C, a unilateral contract requires both parties to perform simultaneously, while a bilateral contract allows for performance at different times. D, a unilateral contract is written while a bilateral contract is verbal. A unilateral contract involves promises exchanged by both parties, while a bilateral contract involves a promise by one party in exchange for an act by the other party. In a unilateral contract, one party makes a promise in exchange for the performance of an act by the other party. In a bilateral contract, promises are exchanged by both parties. What is an example of a unilateral contract? A purchase agreement for real estate. B, a lease agreement for apartment. C, a reward offer for the return of lost property. D, a listing agreement with a real estate agent. C, a reward offered to the return of lost property. A reward offer is an example of a unilateral contract where the offerer promises to pay a reward in exchange for the performance of a specific act, example, returning lost property. Which of the following would not make a contract voidable? A, fraud. B, duress. C, mistake of law. D, undue influence. C, mistake of law. Mistake of law generally does not make a contract voidable because parties are presumed to know the law. However, mistake of fact can make a contract voidable if it goes to the essence of the agreement. What is the doctrine of laches in contract law? A, the principle that prevents a party from enforcing a claim due to undue delay or negligence. B, the principle that allows a party to enforce a claim regardless of delay. C, the principle that requires both parties to perform their obligations simultaneously. D, the principle that governs the legality of contract terms. A, the principle that prevents a party from enforcing a claim due to undue delay or negligence. The doctrine of laches prevents a party from enforcing a claim if they have unreasonably delayed in asserting their rights, causing prejudice to the other party. What is the purpose of the parole evidence rule? A, to prevent fraud in real estate transactions. B, to limit the admissibility of oral evidence that contradicts the terms of a written contract. C, to require all contracts to be notarized. D, to regulate the capacity of parties to enter into contracts. B, to limit the admissibility of oral evidence that contradicts the terms of a written contract. The parole evidence rule limits the admissibility of oral evidence that contradicts the terms of a written contract, promoting the finality and integrity of written contracts. What is the effect of rescinding a contract? A, it validates the contract. B, it terminates the contract and restores the parties to their pre-contractual positions. C, it modifies the terms of the contract. D, it extends the performance period of the contract. B, it terminates the contract and restores the parties to the pre-contractual positions. Rescinding a contract nullifies it, terminating the contractual obligations of the parties and restoring them to their positions before entering into the contract. What is an example of an implied contract? A, signing a lease agreement. B, purchasing a property. C, paying for goods at a store. D, accepting services without explicit agreement. accepting services without an explicit agreement. An implied contract arises from the conduct of parties rather than from the explicit agreement, such as accepting services with an expectation of payment. What is the main purpose of liquidated damage clause in contracts? A, to penalize a party for breaching the contract. B, to provide a predetermined amount of damages in case of breach. C, to specify the payment schedule for contractual obligations. D, to extend the performance period of the contract. B, to provide a predetermined amount of damages in case of breach. Liquidated damages clauses specify a predetermined amount of damages that will be payable in case of specific breach of contract, providing certainty and avoiding the need for litigation to determine damages. What is an example of an unenforceable contract? A, a contract entered into by a minor. B, a contract with an illegal purpose. C, a contract with mutual assent. D, a contract with consideration. A contract with an illegal purpose. A contract with an illegal purpose, such as a contract to commit a crime or violate public policy, is unenforceable because courts will not uphold agreements that are contrary to law. Well, that's our last question. I hope you did well. Once again, please hit the like button. It helps us in the algorithm. It helps us get our content out there. Subscribe, hit the notification button. Also leave a comment or question if you have one, and then also check out our channel. Have a great day.